3 covers equal employment opportunity. By the end of this chapter, you should be able to identify major agencies within the government that enforce discrimination laws within employment, outline the key provisions of the Civil Rights Act of 64 and 91, and be able to compare the two theories of unlawful employment discrimination, show how women are affected by pay, job assignments, and career issues, compared to men, and distinguish between the two types of sexual harassment, explaining how employers can prevent this misconduct, the key elements of disability discrimination laws, discussing legal protections so that you can prevent bias and discrimination within the workplace that can be based on age, national origin, religion, and other factors. When we look at EEO, there are some things that people aren't mindful of. And the fact is that we make employment decisions that can be considered unlawful discrimination based on certain protected characteristics that are actually protected under federal laws, which include a person's age, the color of their skin, any disability they may have, any genetic information, and marital status, and this is only in some states, not all states. And then, of course, military status or experience, because some people discriminate for military, some discriminated against military, some will discriminate because of your rank or because of the branch of military service that you served in. So there's so many different things, and people need to understand that these characteristics are all protected by law. You have to also be mindful of your protection of those based on national origin, so what country they're originally from, if they're pregnant, their race and religion, and any sexual orientation. Once again, that is specific to some states and cities, not all. Under EEO, it's making sure that there is not illegal discrimination in the workplace. This does not apply to outside of the workplace. People can discriminate against you if you go into the restaurant or in their neighborhood. But this is specifically to the workplace. And we talk about, and you might hear the term called status blind. That's where you're making decisions that have no regard to a person's personal characteristics. It's as though you put blinders on. You don't know their the gender, you don't know their national, you're not paying attention to any of that. You're just factoring in the work performed or the role that they serve in, not any of the other characteristics that would personally distinguish them from anyone else. Some of the different sources of regulation enforcement come from our courts, where they interpret laws and rule on various cases, state and city governments, federal statutes that were enacted by the legislature, government agencies that issue guidelines and laws that are and rules for implementation. And then, of course, they're all enforced by EEOC, which is the commission that enforces the employment laws, and the Department of Labor that oversees those compliance with those laws. There are our theories of unlawful discrimination. We have disparate treatment, which is where someone with a particular characteristic that have nothing to do with the job, right? These characteristics are based on gender, race, religion, whatever. That they have particular characteristics that they're treated differently from others because of those characteristics. In this treatment, it is very overt and intentional. It is being done because it's a woman. You know it's being done because this person is African American, or they're Muslim, or whatever. They're in a wheelchair, whatever. You know that it has nothing to do with the job. It is literally because they have a particular characteristic. It will follow a pattern or practice of behavior. People are being judged differently and based on different standards. It's the same standard, but it's not related to one's job. You being African American has nothing to do with you being an accountant, right? It's not a prerequisite to becoming an accountant. and it's you being a woman has nothing to do with your ability to be a construction worker. It's not like, oh, there's not possibility for women to be a construction worker. Now, disparate impact is when the practice that it does not appear discriminatory adversely, but it adversely affects those with a particular characteristic. So, although on the surface it doesn't appear that it is, but it actually does have an adverse effect. And these are usually where individuals of that protected category are underrepresented based on decisions that are made at work that puts them at a disadvantage. One decision that is oftentimes that you will see referenced in human resource management courses is the 1971 decision of Griggs versus Duke Power, which you'll read further about in the textbook, where you can see where you have a group of people who they're not being promoted, offered positions, whatever, and it's clearly a case of that, okay, these protected group of people are being at a disadvantage compared to these other employees. There are various concepts that you will learn about, and they'll be further embedded in your mind when it deals to EEO. The necessity of a business and the job relatedness, how that job relates to the work at hand, and how that can be factored into decisions that are made non-discriminatory. BFOQ is the bona fide occupational qualification. The burden of proof, right, is placed upon the employer. Non-retaliatory practices, so that the fact is that an employee or an applicant, a candidate that brings attention to the fact of this discriminatory practice, that they are then not retaliated against once it's been made known. So with the business necessity is making sure that operations are safe and efficient. BFOQ is you have to have a legitimate reason for excluding a person on something that's on otherwise illegal basis, right? And so it has to be a bona fide legitimate reason for doing so. And then if the burden of proof, unlike, as I said, it's not on the employer, it's on the person who is stating their claim. Can you show that this is illegal discrimination? Is that interesting? Because they're like, well, what's illegal versus legal, right? Illegal discrimination is the fact is that, the fact that there are job factors that are relevant and you just don't meet the requirements and the criteria. So someone can legally exclude you from something because of that. Illegally is the fact is if that it factors in any of the protected categories in which that is clear that those characteristics have nothing to do with the job, and that is the reason why you're being demoted or not promoted or not hired or not kept on. So through the burden of proof, you have to provide either factual or statistical evidence and then build upon that a prima facie case, which can then be presented to a court to support your argument. I've already mentioned this before, and it's been mentioned in chapters 1 and 2 as well, is about retaliation. And in this regard, we're talking about, as it's tied to EEO, in previous chapters, we were talking about whistleblower issues, but they all are the one and the same as far as employers and employees, and candidates are protected from retaliation. To prevent it, you have to be able to adequately train your supervisors, review performance evaluations. Oftentimes, either evaluations are not done consistently, or if they are done, they're not properly reviewed and analyzed. Making sure that when you do an internal investigation that it is very thorough. That way, when an external investigation is done, they can also determine that yes, internally it was done properly and there's no wrongdoing, so on and so forth. Making sure that you take any appropriate action whenever there is a claim, and making sure that, of course, that policy is not only created, but it's disseminated, it is reinforced, it is readdressed on a consistent basis. Title VII, we have the 1964 Civil Rights Act, and it made it illegal for employers to discriminate based on with any factors dealing with compensation, conditions, terms, any kind of privileges because of a person's sex, race, national origin, religion, color. It also made it illegal for them to refuse to hire or not hire someone, to terminate someone, promote or demote someone because of any of those factors. It made it illegal for employers to provide any kind of compensation or working conditions for one group of employees or individual that was different than the other people based on any of those 5 factors. It applies to any private employer that has 15 or more employees. So interesting enough, you'll see that really small organizations see how they're not tied to this. You see how this falls into play, right? 15 or more. So that means if you have less than, does that mean that you should blatantly disregard the law? No. But you will see that this happens. This act applies to all educational institutions, public and private, which that includes our institution, all state and local governments, public and private employment agencies, any labor union that has 15 or more members, and if there's any committees for joint labor management that have any apprenticeships and training. There's other laws dealing with equal employment. The Act of 91 that also requires employers to show that an employment practice, something that was done, a decision that was made, was job related for that particular position and is consistent with the necessity of the business, right? For the day-to-day operations, for it to function and thrive, and that's the reason why it was done. And then there's also a provision that claim where you have any compensation and any kind of punitive damages for the victims of intentional discrimination. And then you have your 3 executive orders that require taking affirmative action to compensate for any kind of historical discrimination against protected class individuals. And under that falls your affirmative action, which most people think that that's, when we talk about minorities, people think about racial minorities and the fact that it provides a sense of practices and compensation for those that have been discriminated against. But it's not just minorities, this also includes women as well. So it covers that as well. And to be very clear, that's all women. So it's not just racial minority women, it's all women, including white, Asian, Latino, blah, blah, blah. Figure 3.3, there are some penalties under the 91 Act that are factored in based on employer size. Once again, as you see, the cap number is 15. It does not apply to those that have fewer than 15 employees. But the penalties for violating these can range up to $50,000 if you have 15 to 100. If you have 501 or more employees, that penalty can be $300,000. How we manage the requirements under affirmative action, we create a plan. It's an action plan. It's a program that is created that outlines your steps that you'll take to attract and hire members of underrepresented groups. This can also include your military personnel. It can include your aged population. It can include. It can also include individuals who have who were recently or have been released from um, the prison system, so formerly incarcerated individuals, how you can go about that as well. And there's objectives that are tied to your demographics that can look at the labor market and from where you're recruiting to see how best you can meet the needs and make sure that you have a well representative workforce within your company. How you can deal with discrimination issues, there's various solutions where you're making sure that the decisions that you make and any questions that you ask are specific to the job at hand. They have nothing to do with any other factors. You can also use an anonymous application procedure that can then make sure that it's a blind decision that's being made, not one that is very conscious and alert to who the individual or group of people are. Coming up with various policies to address harassment, making sure that jokes about ethnicity, any kind of vulgarities, racial slurs, anything dealing with religious jokes, any kind of physical actions that could be categorized as harassment, all of those need to be addressed. Basically, it is not being, some people are like, oh, we're all super sensitive, but it's being mindful of the fact that our culture of within a workforce is more diverse, and you have to take in consideration who can we possibly offend or hurt or insult based on the things that we say and do. And so it's making sure that you're going through that list and you're considering if this were me, how would I feel if someone said or did this? Looking at our sex and gender discrimination laws, understanding that there has been a long history of discriminating against women who are pregnant. There's also been a long discrimination against men who want to spend time with their newborn children and their significant other. And so making sure that we treat maternity leave as we do all other medical leaves, and then also taking in consideration FMLA, which gives up to 12 weeks unpaid family leave, and allowing you to come back to your job. Sometimes you may not be returning to that same job, and your employer will be very specific about that as well. Also, there's various factors that come into FMLA. Sometimes you have to have already been employed with the company for so many days or so before you can actually be eligible for it. Then you have Equal Pay Act, where making sure that regardless of gender that there's a similar wage rate for the same work being done or something similar being done, that there's not a huge gap in between what one gender is being paid versus another, and making sure that men and women are permitted to that the pay that's allocated, that there is a difference based on seniority, performance, and working conditions, right? That you're looking at all of those factors and making sure that it's also a genderless, neutral position that's being taken. When we look at pay equity, we're seeing how one's knowledge, their ability, and their skills, where there's a compare and contrast. And there should be a similarity, even if the actual duties are slightly different, is making sure that men are not being paid more or less than women and vice versa. This is what we also call comparable worth. And the reason for enforcing this is to make sure that we're narrowing this gap between what women make versus men. Men shouldn't be making, a full dollar, and women are making 50 cents for doing the same or similar job. So it's making sure that we're narrowing that gap and understanding that the gender has nothing to do with the job at hand. When we look at the median hourly income of a woman compared to a man in figure 3.4, you see the charts for 2005 compared to 2012. And it has all women ages 16 and up, and then it has millennials. It's interesting we're having this focus on a specific generation category, ages 25 to 34. And with that, you can see the percentage of women in both categories, in both time frames, as well as millennials. And you see that millennials in both 2005 2012 actually made more than women. So, oh, and if you see below the note, it says these represent civilian, non institutionalized, full time and part time employees with positive incomes. So, this does not include self employed individuals. It does not include anyone who is incarcerated. So, just making sure that it covers that, okay? Now, how we can help reduce this inequity. Where you're making sure that all benefits are calculated towards total compensation, that people know how the pay practice works. You have to be able to educate your workforce so they understand. It's very clear why you're getting paid, the amount you're getting paid, and in comparison to someone else within your company or within the labor market as a whole. You have to make sure the base pay is on the value of the jobs and the performance. Make sure that you're looking at local and national markets to see that you're staying within a competitive range, and then be able to benchmark accordingly. You don't want to be paying, $10 an hour, and the rest of the market locally is $15 an hour, and nationally it's $20 an hour. You're off. Right? So you need to make sure those structures are competitive, and then making sure that you're conducting frequent audits. And so whether or not you're doing a quarterly or semi-annually or annual audit, that you're staying on top of it to make sure that your people are getting paid what they need to be getting paid and that pay is competitive. And there's never a question as to whether or not someone's getting paid more or less based on any kind of bias, discrimination, so on and so forth. We talk about the glass ceiling, and this is usually a factor of that we're talking about women and minorities, where you reach a certain point and you just can't get above that. You are trying to get to the top of the corporate ladder in those executive level jobs, and there are practices that have been put in play that are discriminating and blocking you from doing so. And there's the glass elevator that they have for women, where you can only reach a certain level, right? And that's it. You can't get above, you can't get beyond. And so women are trying to find ways in which they can either acquire more education or more skill sets, or form stronger alliances, or some way that I can now get above where I am, so that I can progress and reach, my goals on my career path. The glass cliff is anytime you are promoted to top management, but only when the company is failing, right? It's basically you're now given this position, the company is failing, and okay, now you got it. But the thing is, unless you have what it takes to rally the troops, in a sense, to help rebuild the company, to keep it from failing, at that point when it fails on your watch. So all people will ever realize was that you were in that position, or whatever that position is, but you were in that position when the company failed. You didn't help it get to that point, but all people remember is the last leader that was in that place. And that's the glass cliff. How we can go about breaking the glass: creating and reinforcing mentoring programs that are formalized and structured, that, of course, the senior most leaders on your team support, providing different opportunities for employees to rotate through the career, making sure that women and minorities are in top management positions, Making sure that you also have women and minorities on your board of directors and board of advisors. Establishing clear goals for how you can go about retaining women and minorities, how you can help progress them up that corporate ladder, how you can create various alternative work environments for your employees so that you're making sure that you're seeing through all the lenses and different opportunities that can be presented for you. When we talk about discrimination based on sex, there is no federal law that prohibits discrimination on the basis of sexual orientation, right? There's 18 states that have passed laws to protect discrimination on the basis of that, but not any that prohibit it. Because remember, we talk about sex, but we don't talk about, and when we talk about sex, we're talking about gender. We're not talking about your sexual orientation. And so under Title VII, it applies to a person's gender at birth and not to new gender as a result of sex transformation operations. So what the current standing is that if you were born a boy and then you've had a gender reassignment surgery to now become a girl, to become a female, you're not protected from being discriminated against. So that's the thing. And you see only 18 of our states have passed laws to protect. So that's something that, of course, is still being worked on. Nepotism and romance at work. This is a biggie. Nepotism is anytime you allow your relative to come work for the same employer. And what happens is that usually there's a lot of bias because that is your cousin, that's your sister, that's your brother. That's a big thing because oftentimes the resentment grows internally within the organization because people believe that, if this person isn't pulling their weight and then some, then that means that person's getting a free pass and free pay. And it causes a lot of friction within the organization, a lot of discord. Workplace romances are oftentimes, sometimes they are prohibited, but most organizations at least have some kind of policy about workplace romances. They understand that they can occur, of course, anytime you work closely with someone else, but a lot of organizations are addressing this. And the fact that you have to respond to what is considered fair, because especially if that workplace romance takes place between a manager and their team member, their subordinate, is there a perception of fairness or not? Is there bias or not? And so you have to be mindful of that. And from an HR perspective, is understanding that with the nepotism and when the workplace romance, these are both risky areas that have great potential for causing conflict as well as conflicts of interest. Sexual harassment is anytime someone is verbally, visually, or physically conducting themselves in a way that's not welcome. You don't like it, you don't want it, you didn't ask for it. And it's in a sexual way that can impede, affect, can destroy the working conditions. It can create a hostile work environment. Anytime someone is passing along a picture or a sound bite or making a comment or a joke or touching you, or it could be massaging your shoulders or, flashing you, undressing themselves, whatever, licking their lips, any kind of thing that you did not ask for and are not willingly participating in, that is deemed sexual harassment. And this can happen by a boss to their subordinate or vice versa. It can be perpetrated by men as well as women, old and young, right? The reason why most people don't report sexual harassment is because they're embarrassed. They fear that they're going to be retaliated against. Some don't even realize it's sexual harassment. And then especially if you have a person who tells you to lighten up, what's your problem? We're all doing it. what happens is you're confused as to what is really deemed as sexual harassment. So having a strong policy and program in place that educates your workforce to understand this will help to reduce it. When we look at the different types of sexual harassment, we have a quid pro quo, which basically is like you scratch my back, I scratch your back. Usually the person who initiates this is the person who has a superior position over the other person. They have a sense of power over them. And you have the power to discipline or promote, punish or reward this person. And so what happens is that you're then requesting some kind of sexual favor, whether it is through visual, auditory, or actual tactile sexual favor. In this regard, the company is liable, right? Because you're having a person who has undue influence over another, and they're using that job as leverage. In a hostile environment, you have it can be any number of people. It can be the manager, the CEO, it can be any of the coworkers, it could be a third-party vendor, it could be a board member that is engaged with this, and it can happen to, or it can happen from. So meaning it could be that the employee harassed the board member, or vice versa. Once again, any kind of jokes, anything that can create a dysfunctional workplace, it falls under this. There are some times where the company is liable, but only that is the case if they can't offer a defense as to why it was done, right? If they can, then they're not liable. It's then, of course, the party that was the perpetrator. So some of our current issues we have, of course, are gender stereotyping. We do it a lot. We assume that, women do say certain things, men do say certain things. We use electronic sexual harassment through texting, email, instant messaging, social media. Some major rule of thumbs. These are things that employees just should not do, no matter what level you are in the company. You should not email someone inappropriate content. If you would not want it to be reported on the news, be shared with your mother, your grandmother, your religious leader at your church, whatever. If you don't want your future employer to know about it, don't email it. Employees should not access inappropriate social networking sites, content, and the internet. Don't click on the XX.com sites. Don't share sexual jokes. Don't share any photos of anything that could be deemed inappropriate. Don't look at pornography at work. Don't look at it and share it. If someone sends it to you, don't forward it. Of course, every country has its own limits of tolerance. Some are more open, some are more conservative. So it's understanding that it can vary by country, and so you have to take in consideration of that as well globally when that happens. How we can prevent it. As I mentioned earlier, create a policy, enforce that policy, make sure that the top leaders are fully engaged with pushing that policy throughout the organization, training everyone, including your senior-most leaders, on how to avoid it. And whenever a complaint is voiced, investigate it, understanding that you have to investigate it and take action, and being mindful of this, that it's not just the person who could possibly be physically, that may be the direct recipient of this harassment. Understand that it could be any person. If you see it yourself or you hear it, you could be offended by it. That is harassment. So if you then go to your manager and you say you saw, Susan share this picture with Bob, and you feel it was inappropriate, you feel offended, it is up, your manager is supposed to take that to HR or direct you to go directly to HR. Who HR is to investigate it and take action immediately, not delay, not redirect, the whole nine. You guys will see that I'm going to be providing you with examples of current issues, HR issues that have been happening with very large institutions, where you'll see that it's people are just not moving. They're not investigating. They're not taking action. They're just sweeping things under the rug. You can sweep all you want. That rug is going to eventually become so high that all the dirt is going to be exposed. So you need to investigate and take action. Now, we talk about discrimination of those with disabilities. We have some important acts that you must be mindful of. And one is a Rehabilitation Act, where you're considering your disabled workers and applicants, and you're providing them with opportunities with federal contractors so that they're able to work. The Americans with Disability Act is enforced by EEOC, and that will apply to private employers, any agencies and labor unions that have 15 or more employees. Americans with Disability Act Amendments Act, right? There's all these acts and amendments. Helps to broaden that definition of who is considered disabled, and the various impairments. But it's without regard for any kind of medication or prosthetics that are needed. So you can be one of these three and be defined as a person with a disability, either having a physical or mental challenge that significantly reduces your ability to do the day-to-day life functions. You can possess a record of a challenge of such. If someone perceives, they think that you have a challenge, then any of those three fall in. So even if someone doesn't say they have a challenge, if I perceive they do, then it's being mindful of the fact that, okay, be mindful of how you proceed with this individual. And then it's considered a disability even if corrective measures are taken to help remedy the issue. And then, of course, this also includes internal bodily functions, not just external. Most people consider the external factors of, oh, this person is blind, or they can't hear, or they're paraplegic or quadriplegic, or they're in a wheelchair, or they have prosthetics. It's also considering any internal factors as well that would provide any limitations. The mental disabilities are any kind of mental or psychological disorders, which can also include anxiety, depression. When we think about PTSD, any kind of temporary injuries that may not be long-term, but they can temporarily create barriers for you. And then if you develop a disability, right, that's something that can happen while at work or even outside of work, but during this period of time, where there's shifts to jobs where your disabilities don't affect you as much. There are some requirements based on our essential job functions and what is fundamental to you getting the job done, what duties that are required to achieve your goals within the organization, and what kind of accommodations can the job make to modify either the job or the environment in which you work that would allow you to then be able to do your job best, right? Because you have to be, of course, qualified. You can't be unqualified and you get the job. But based on the fact that you're qualified, how can we be able to reasonably accommodate you? Figure 3.6 looks at how job functions are deemed essential. And I'm going to expand this so that we can hopefully see it closer. There we go. So if you see that the function may be essential because there's limited number of employees that are available who could perform that particular function. And then when we look at the evidence of whether a particular function is essential, includes, but is not limited to, if there's a collective bargaining agreement, that any of those terms that are factored in, the amount of time spent on the job performing the function, but also your judgment as an employer as to which functions are deemed essential. Some of you have heard of, may have been involved with, understand the concept of undue hardship. This is when there's significant difficulty or expense that's imposed on an employer when they have to make an accommodation for individual disabilities. If you work within HR or you're a manager, you may have actually sat in a meeting where this is discussed. And so there are certain guidelines that are provided to help address this hardship. And they're always determined on a case-by-case basis, where you then sit back and say, we just cannot afford to make these accommodations any longer because of these specific factors. So you may have, as I said, have been on either end or sat in on a meeting or read a report about that within your own organization. So here's some different ways in which we can accommodate workers, reassigning their jobs, creating or providing special equipment, restructuring their job, giving them more time to train so they can better embed the process and the concepts in their mind, provide various assistance, and creating modified work schedules. The guidelines to do this include making sure that you identify the functions that are essential to performing the job, what accommodations are reasonable, any kind of barriers to the building in which they work that don't block access, what specific tasks have to be assigned or modified to allow the workers to perform their work adequately, and what hours and breaks in the day have to be adjusted. There are certain restrictions that prohibit you from rejecting someone because of their disability, asking a question to an applicant about any current or past medical history until a conditional offer is made, using any kind of pre-employment medical exams, except for the only medical exam you can use is drug testing. You can't use any kind of other medical exam until a conditional offer is made. And then, of course, any medical information must be stored separately and securely so that it cannot be easily accessible by other employees or external individuals. In 2013, the most frequent charges that were filed were other disability, right? But you see, regarded as having a disability, depression, 7.1%, anxiety disorder, 6.4%, diabetes, 4.7%. When we look at regulations that are tied to genetics, employers can use genetic screening to make workers aware of any problems they may have, to terminate employees who may make extensive use of health insurance benefits. You can, at that point, that's tied to that undue hardship, that if this person has some kind of genetic condition that is costing thousands and thousands and thousands of dollars to the employer, they can actually, terminate the employee based on that. There is a Non-Discrimination Act which will limit the use of that information by health insurance plans, which is a good thing because health insurance companies could use that to exclude or increase the cost to the employer as well as the employee. And then it prohibits the employment discrimination on the basis of that genetic information. Age discrimination, as I said, if you're 40 or older, you're considered aged. Right? The ADA prohibits discrimination if you have 20 or more workers. So if you are working for a company that has 19 or less, guess what? They can discriminate against you, and whether you know it or not. Older Workers Benefit Protection Act is an amendment to ADEA. I'm just speaking too fast. It protects you if you sign liability waivers for age discrimination in exchange for severance packages. How do we go about managing this? It's a huge problem. Some states it's ridiculous. I was told that the state of Oklahoma is like ranked number 2 in the entire country for age discrimination. We can come up with an age-neutral selection and promotion practices that have nothing to do with age, like where you just don't even factor that in. And I think one of the things is that I think that when we have people submit resumes and doing these applications, the moment, before it was just like, oh, leave your high school information off if you're not a recent high school grad. The thing is that, as I mentioned in, I believe, the chapter 1 lecture, is the moment I list that I have 20 years of experience, at that point, you know that I'm not in my 20s. And you know I'm not even in my early 30s. So at that point, then where's that room in which we can be neutral in how we select an employee, how we decide who we're going to interview and recruit. And the thing is once even if you get past the initial selection of, okay, we're going to call her in for an interview, the moment you see me, you can then discriminate, just bias looking like, okay, this person has gray hair or wrinkled skin. Oh gosh, it's going to cost us a lot. They're going to be a stickler. They're going to want more money. This is going to be a headache. We need someone younger. So you have to be able to create something that's age neutral. And then being mindful of recruiting older people to return to the workforce through part-time opportunities, as well as other attractive scheduling options that you can come up with. There's some flexibility, because with that age comes wisdom, comes experience, and you can get someone to come in to do work with less uptime and training because they already know how to do it. Something else is a phased retirement, where you're gradually reducing workloads and pay level to eventually phase those workers out over time. So whether or not you phase them out by 65 or by 70, right, in some regards, you then gradually reduce their workload so that they still are in the workforce, but they're not pulling in the 60 to 80 hours a week. They may be pulling in, 30 hours, and as time progresses over the years, you may have them where they're only coming in and doing 15 hours a week or whatever. Their pay can adjust accordingly. In 2012, in the U.S. alone, Gallup did a poll from January 2nd to November 30th, and it was called Matters of Faith, and they found that the religious preferences, you have Protestant or other Christians ranked at 51.9%. Catholics are second at 23.3% of people. That's the preference that they identify with. Then in third are people that have no religious identity at all. You have a group that just didn't respond, 2.2%, right? But it's like interesting enough, and the reason why this is really interesting, this is 2012, here we are. You see that Muslims, 0.6%, such a small factor. Jewish people, 1.7%, Mormon, 2.1%, other non-Christian, 2.6%. So interesting. We have this boiling point in the United States about Muslims, and if you see that it's 0.6%, such a small, it's the smallest part of this pie. But the thing is that with that, you tend to see higher discrimination and hostile work environments geared towards and targeting Muslim individuals. So it's just an interesting dynamic when you look at it that way. But when you look at Constitution, Bill of Rights, federal laws, everyone in this pie chart is to be protected under the law, regardless of your religious preference or views. But when we have to understand that your religious beliefs, your spiritual beliefs are always brought into the workplace, no matter how much you try to say that it won't or it doesn't or shouldn't be. So we have to be mindful of the remarks we make, or if we're refusing to hire or promote someone because they have different beliefs than us. We have to be mindful that people are allowed to express their religious beliefs, their practices, and that they're supposed to be protected. So if someone needs to go pray 5 times a day, whether they're praying there at their desk, at their cubicle, or if they step away, they're supposed to be protected by that. Making sure that we manage the diversity and changing any kind of task or scheduling to accommodate one's religious views. Making sure that we're making exceptions to dressing and grooming, and understanding that someone may not feel comfortable based on their religious beliefs in wearing a certain thing, or understanding that people groom themselves differently. Making sure that things that are dealing with paying union dues or agency fees, we're making accommodations, because some people, based on their religion, are not supposed to be paying into or involved in unions, and understanding that some companies have a relationship with unions, that the union will represent all employees, right? And so at that point, then all employees are supposed to be paying a membership dues to that union for representation. And interesting enough, if your religious views differ from that, like for instance, whether you're Mormon or Jehovah's Witness, where there's no voting, and of course there's no tie-in with certain things of that nature, that is basically you're an affront on their religious views. As I mentioned earlier, accommodating prayer, as well as other forms of religious expression. Immigration reform requires that you verify eligibility of your employees, their status, without discrimination. That the first 3 days of employment, that everyone complies with completing an I-9 form that verifies their eligibility. It broadens the visa requirements to make sure, that we're accommodating highly skilled employees, that you're not discriminating against employees. You're also not just seeking out lower skilled employees, and vice versa. It allows you to be able to recruit highly skilled employees from all over. There are certain documents that are tied to this. There's 3 lists, which you can provide your passport, any kind of permanent residence card, your driver's license, school ID, a voter registration card, if you have a military card or draft record. If you were born overseas, you can provide that birth certificate, your U.S. Social Security card. If you're Native American, you can provide your tribal document. So any of these things will factor in as primary documents. When we look at language, and there are some barriers to language, there are certain guidelines that state that you have to require workers to speak only English at certain times or in certain situations. But the business necessity of the requirements must be justified. So if they don't, if, for instance, there's no interaction with an external individual, with a customer or vendor, then no, it may not necessarily be justified to say that they have to speak English. Why? Who are they speaking to? So it's those things have to be outlined as to why it is justified as a requirement. We have your USERA, which is your Uniform Services Employment and Reemployment Rights Act. These are provisions that deal with leaves of absence when you're trying to return to employment, the rights that you have. That return is prompt, that you are protected from any kind of discharge or retaliation, that your insurance is continued, and that you also maintain your seniority rights. Here's something else that's a huge one. How you're discriminated against based on your appearance and your weight. You can set a uniform dress code and appearance standards as long as they are applied uniformly. They cannot be applied to, um, you know, certain people based on how they're built or they look, or because one woman has um, long legs and one guy has broad chest and big arms. Um, or there's something that's based on the fact that, the average weight of your employees is 180, and you've got a couple employees that are 350, and now you're coming up with a different uniform for the 350-pound people, or vice versa. So it has to be uniformly, and height and weight requirements must be specific to the job functions. If they have nothing to do with the ability to perform the job at hand, then the requirements to height and weight are not enforceable. We talked about in previous chapters the importance of diversity training, making sure that everyone's legally aware, culturally aware, and that they're sensitive to the fact that we are all diverse. We all have our issues. We all have our buttons that can be pushed. And the fact is that we're all due the dignity and respect as individuals. There are, of course, some mixed results, because sometimes they don't produce longer term changes that we would require, that we would expect in people's attitudes and behaviors towards others. Sometimes it just has a short term band-aid on it. It has not reduced discrimination and harassment complaints at all. And it seems to only be benefiting women and racial minorities. That takes away opportunities for men and non-minorities. So it has to be clear across the board, and being mindful of the fact sometimes we are very focused and hypersensitive to women and racial minorities, and we're not considerate of the fact to men and non-minorities. And the fact is that they can be discriminated against, they can be harassed, they can feel isolated and feel different, or that just out of the loop. And so you have to cover all those bases. You have to look through all of the lenses as an HR professional when you are creating these training opportunities. So you can improve the efforts by focusing on behavior itself. When you focus on behavior, then it's non-gender, it's non-racial, it's just focused on the actual behavior, and understanding that behavior can be displayed by any gender, by any race. Teaching your team members how to communicate with people from various backgrounds, and understanding that we need to look through the different lenses and walk in different shoes, and understanding that when we're dealing with, it's not about what people can and can't say, it's about being respectful to others, right? You're not trying to silence or to dictate, what to do or say. It's just being respectful. And being mindful of, would you want the things that you've said and done broadcast on the news, shared with, the world? If the answer is no, then don't do it. Don't say it. So with that is the end of chapter 3. If you have any questions, please email me. Thank you.